Okay, good morning and welcome everybody to today's webinar. Today's topic is credit unions, know your rights when debtors file for bankruptcy. My name is Scott Fink and I'll be the moderator today. I'm a shareholder and I manage the firm's bankruptcy group. Our bankruptcy group focuses solely on representation of creditors in a bankruptcy setting. We focus our practice on both consumer and commercial bankruptcy cases. Me personally, I'm a member of both the Cleveland Metropolitan Bar Association, the Ohio State Bar Association, and the American Bankruptcy Institute. And I've been an active supporter of the credit union industry throughout my years at Weltman. We really love the credit union movement. Before we get started, I do want to take a couple of moments to go over a few housekeeping items. As a reminder, this is an interactive session, so please submit your questions through the question button in the control panel. Questions will be addressed during the presentation where applicable. The webinar is being recorded. So at the conclusion of today's session, a link to the recording and a copy of the slides will be sent to all of you. Lastly, there will be a short survey on your screen at the conclusion of the event. Please take the survey and share your feedback. We greatly appreciate hearing your opinions on our webinars. And we will plan to conclude this by noon. All right, so just a little bit about Weltman before we get started. So we are a nationally recognized full-service creditors rights law firm. We represent nearly every type of creditor. Some of the largest financial institutions in the United States are our clients. We focus on bankruptcy, commercial and consumer collections, litigation, and real estate defaults. And when I say we're national, we have a large footprint, both that we handle directly as well as our network. You can see there the states. I'm not going to list them all for you. You can read. But the bankruptcy footprint where we have Weltman attorneys who hold licenses in those states, meaning if you send us a case, one of the Weltman attorneys will handle all of those states directly without going out to our local counsel network. But if one of your bankrupt members does happen to file in the state that's not listed there, that's not a problem at all. We have a full full national network of attorneys, firms that do exactly what we do. They are fully vetted, they have contracts with us, and they will handle those cases on our behalf in other jurisdictions, and we will continue to be your main point of contact on all those files. All right, so with that in mind, I would like to introduce today's presenter, Milos Gvozdenovic. He is our lead attorney who practices out of Weltman's Cleveland office. He's been practicing bankruptcy law for more than a decade. Milos seeks to protect his client's interest during every phase of the bankruptcy process. His goal is to maximize your financial return while adhering to the rigorous rules of bankruptcy courts and upholding our clients' images within the communities they serve. He's extremely active in the Northeast Ohio credit union community, conducting in-house training and participating in several credit union events throughout the year. So without further ado, I'm going to turn it over to Milos.
Thank you, Scott. Thank you, everyone, for listening. This is something we decided to put together. Historically, I like to get out to the credit unions and do some one-on-one or small group training. Because of COVID restrictions, obviously that's been put on hold for a very long time. And we wanted to kind of put something on to be able to reach as many clients as possible to kind of get everybody up to speed and make up for the time that we lost during COVID. So I'm going to jump right into the materials. And if you guys have any questions, feel free to ask questions as we go along, and we'll try to answer them as we go. All right, the first thing I want to touch on is the automatic stay. The automatic stay is governed by 11 U.S.C. Section 362. What is the automatic stay? The automatic stay is an automatic injunction which halts actions by creditors to collect debts from debtor who filed for relief under the Bankruptcy Code. It applies to every chapter of bankruptcy. So it doesn't matter if the debtor filed a 7 or a 13, 11. It does not matter what type of bankruptcy they file. The automatic stay applies the same for each bankruptcy. That's part of the reason I want to touch on the automatic stay, because no matter what bankruptcy one of your members files, the automatic stay always comes into play. The automatic stay takes effect automatically when the case is filed, and it's effective even without actual notice. So what does that mean? Common question I get is, well, debtor filed for bankruptcy, we never got any notice. That the notice doesn't matter. The fact that he filed the bankruptcy stay goes into effect immediately. Another common credit union question I get is, what happens if we didn't get notice and we violated the stay? The first thing I say is you just undo it. If it was an honest mistake, there should be no issues. Common scenario, you guys send out a repo to repossess a car. Debtor files for bankruptcy. You're not aware of the bankruptcy. You repossess the car. A couple of days later, you either get a call from the debtor, his attorney, or you get a notice from the bankruptcy court. Where do we go from there? Obviously, I don't think anybody expects you to be telepathic and know when somebody files for bankruptcy immediately, so these things do happen. As long as you make the effort to undo what's been done in violation of the stay and do it timely, usually there's not going to be any issues with the debtor, debtor's counsel, or the court. So what does the automatic stay actually do? 11 U.S.C. section 362A kind of outlines the things that are restricted by the automatic stay. Prevents any acts against the debtor to commence or continue lawsuits against the debtor, enforce judgments against the debtor or their property, obtain possession of debtor's property, obtain or perfect liens against debtor's property, or collect or recover claims against the debtor. Okay. One thing I wanted to touch on specifically in this presentation, and it's a very common issue, and it's been coming up quite a bit lately, and it seems to be very credit union specific, is auto payments. I know a lot of times you guys, when you issue loans to debtors, whether they're secured or unsecured, you enroll them in auto payments where they get money deposited into their bank account with the credit union, and you withdraw payments for the monthly payment on the debt. When a debtor files for bankruptcy, these auto payments need to stop immediately. Okay. Even if the debtor indicated they wanted to, even if the debtor voluntarily set this up prior to the bankruptcy, you need to terminate the auto payments. My recommendation is, if the debtor reaches out or contacts you and says, I want to continue making my voluntary payments, can you set up my auto payments again? I would probably, or I wouldn't say probably, I would request that they put something in writing, either a letter or an email, something to that effect. That's more so to protect yourself if the debtor changes his mind. One thing that I've encountered a few times with credit unions is debtor files for bankruptcy, they have an auto payment, a representative of the credit union speaks to them over the phone, they verbally tell them, yeah, I want to continue making my payments, and then a few months later, for whatever reason, they change their mind, they come back and say, I didn't want to pay on this loan. Now you're in a situation where it's your word versus the debtor's. Typically, I think what it would come down to is the court would look at it and say the credit union should know better. Automatic stay was in effect. The auto payment should have been terminated. That way, if you have it in writing, you can turn around and say, well, you told us you wanted the auto payments deducted from your pay. We didn't just do it, in violation of the stay. We terminated it and then reinstated it at your request. And you want to get that in writing to protect yourself. Okay. Next thing I want to touch on is co-debtor stay. I know that's a thing that's come up quite a bit recently as well. It applies to consumer debts only. So consumer debt is defined in the bankruptcy code as a debt incurred by an individual primarily for a personal, family, or household purpose. So that would be mostly in situations that the credit unions encounter. I think a business filing, there would be no co-debtor stay. I don't think you guys get too much of that. The automatic stay in a Chapter 13 applies to non-filing co-debtors on loans with the bankrupt debtor and prevents actions by creditors against non-filing co-debtors. So common scenario for credit unions would be situations where you have a member who obtained a loan. They have a co-signer, or they co-signed for a family member, and then one of the individuals files for bankruptcy, the other does not. In a Chapter 7 scenario, you are allowed to pursue the non-filing co-debtor. There is no co-debtor relief. Okay, so if dad co-signs for an auto loan for his daughter, daughter files for bankruptcy, dad does not, you can continue contacting dad, you can file a lawsuit against dad, you can continue moving forward against the co-debtor, but only in a Chapter 7. Now, if the co-debtor filed a Chapter 13, you cannot pursue that co-debtor without relief from stay. So that's a very important distinction to know when somebody files for bankruptcy. So how do you get around the automatic stay? So now we'll go to the next slide, talk about the termination of the automatic stay. So there's two ways that you could terminate the stay. First is by operation of law. Okay. Absent an action by the creditor seeking relief from stay, the automatic stay remains in effect until the case is discharged, dismissed, or closed, whichever occurs first. I wanted to take a moment and kind of talk about the terminology there and what those things mean. I know that at our last webinar, if you attended, we did touch on that. That was a question that came up, and I wanted to kind of address it again in more detail just to make sure that you guys are aware of what each of these terms actually means. You know, because if you mix up the terms, if you mix up a discharge or a dismissal or a case closing, and you do something you're not supposed to do, that could spell a lot of trouble for the credit union. So basically what a discharge is when the debtor obtains a discharge of all their debts. Whether they file a 7 or a 13, that's their ultimate goal. So when a 7 completes or a 13 completes, their goal is to get this discharge. Once the court issues that discharge order, all the debts that they owe have been discharged permanently. Okay. Now, if a case gets dismissed, what happens is the case was not completed for whatever reason. The debtor failed to take the necessary steps to complete their case. Almost 100% of the time, if a case is dismissed, it's usually dismissed before the discharge is issued. Dismissals are usually done if there's some egregious error where the case cannot complete to the end. Okay. Now, closing of the case is essentially administrative closing of the case. So a debtor can obtain his discharge in a 7, and the case can remain open for years. Commonly, what happens is the debtor gets his discharge, and the bankruptcy trustee is still administering the estate, recovering assets for distribution to creditors, and that case may remain open for years. So when a case is discharged, it doesn't necessarily mean it's closed. Same thing with the dismissal. A case can be dismissed, which would give you relief from stay, but it may stay open for a period of time for the trustee to administer the estate, wrap up some paperwork, file some documents with the court before officially closing the case. So termination of the stay by law, and then we could terminate the stay by motion. So motions for relief from stay. Go to the next slide. A creditor seeking to commence or continue with foreclosure or repossession and sale of collateral must establish that as a result of the debtor's failure to maintain current payments on the loan, creditor is not adequately protected. A creditor must also establish that little or no equity exists for benefit of the bankruptcy estate. So essentially what we're doing in that scenario is we're filing a motion for relief from stay, and we have to prove to the court why we're filing the motion for relief from stay. We have to show that you're not getting adequately protected, you're not receiving payments, the collateral is not insured, and we have to show that there's not equity in the collateral. A lot of times, if the collateral is oversecured, if there's more than enough equity to protect your secured interest, that may be grounds to deny a motion for relief. And we'll get more detail on those as they apply to the different bankruptcies. So the next thing I want to touch on is Chapter 7 bankruptcies. So
Milos, before we move on to Chapter 7, I do have a timely question that really relates to the automatic stay. We had a question from the audience about auto payments that are set up, auto deducts on loans. When a member files for bankruptcy, regardless of whether the question really related to when they state their intent is to reaffirm, does the credit union need to stop those auto payments on the loan? So.
I would say yes. Until you get the reaffirmation or some other confirmation from the debtor post-petition that they want to resume those payments, I would terminate them. Even if they reaffirm, you probably still want to make sure that they want to make it as an auto deduct. I wouldn't rely on the statement of intention or any kind of verbal promise by the debtor that they're going to reaffirm, because I'll tell you that that's not set in stone. Statement of intention is not. They're not bound to reaffirm if they say they're going to reaffirm. They can change their mind after the bankruptcy and say, you know what, thought it was a good idea. I decided I'm not going to do it. So I would still terminate those auto payments unless you get some sort of confirmation in writing.
Thanks, Milos.
No problem. Okay. Chapter 7 bankruptcy. So the most common bankruptcies that you guys will probably encounter, I doubt that you'll see anything outside of these two, is what's called the Chapter 7 and the Chapter 13. Chapter 7 is the most common type of bankruptcy. Chapter 7 bankruptcy is a liquidation bankruptcy used by either individuals or businesses. The debtor surrenders their non-exempt property to a bankruptcy trustee. The trustee then liquidates the property and distributes proceeds to the debtor's unsecured creditors. In exchange for this liquidation, the debtor is granted a discharge of their debt. So proof of claims in a Chapter 7. Common question I get is, do we have to file a proof of claim in a Chapter 7? If you could go to the next slide. You don't need to file a proof of claim in a Chapter 7 bankruptcy unless you get notice from the trustee to do so. So if bankruptcy is filed, no need to file a proof of claim unless you get notified to do so. Proofs of claim in Chapter 7 are usually reserved for unsecured creditors only. The distributions are paid by the trustee to unsecured creditors. The exception would be situations where the debtor is surrendering collateral, securing a loan, and there would most likely be a deficiency balance. So what I mean there is a debtor files for bankruptcy, trustee recovers assets, credit union gets a notice, hey, we recovered assets for distribution to unsecured creditors. You guys have a secured loan secured by a motor vehicle. Do you file a proof of claim? Well, if the debtor is paying on it and is current, or they plan on reaffirming, there's no reason to file a proof of claim. If they plan on surrendering the collateral, or if they've fallen behind on payments and you anticipate at some point in time repossessing and selling that collateral, then I would probably advise on filing a proof of claim. Particularly, or I wouldn't say particularly, typically you'd only do that in a situation where the value of the collateral is not enough to pay your loan off in full. So if the vehicle is underwater, if the debtor owes $10,000 and you anticipate you're going to get $5,000 at sale of the collateral, there's going to be a $5,000 deficiency balance. In those scenarios, you probably want to file a proof of claim in the Chapter 7 to be able to get a distribution on that unsecured portion. Common thing that comes up is, well, I don't think I'm going to be able to repossess this car and sell it in time to meet the trustee's claim deadline. What I would recommend in those situations is we would probably want to file an estimated deficiency claim. So we've had success with almost no pushback on filing an estimated claim. So what we would do is we would take a look at what the blue book value of the collateral is versus what you owe on the loan. And then we would subtract the blue book value from the loan and do an estimated claim, estimating what your deficiency is going to be. That way we get our foot in the door, file a timely claim, and not have to worry about any kind of claim deadlines. What would happen then is eventually when you sell the collateral, we would go back, amend the claim, and amend it to reflect the actual deficiency after the collateral sells. And that should protect your interest enough to be able to get distribution paid as a general unsecured creditor for that deficiency. So, Chapter 7 and secured claims. So next slide. A Chapter 7 discharge does not affect a creditor's lien. A bankruptcy discharge will eliminate the debtor's personal liability on the debt, but your secured interest in the collateral will remain in place. So what does that mean? Usually this is a concept that the debtors are very confused about when they file for bankruptcy. So once again, car loan scenario. You have a member who has a car loan. They file a bankruptcy. That loan is discharged. You can never pursue them for that debt unless they reaffirm, and we'll get to that later. So, but you still retain your lien on the collateral. So when the bankruptcy is filed, debtor gets the underlying loan discharge, you never lose your right to repossess and sell that car. So if the debtor wanted to keep that car, even though the debt was discharged, they would still have to pay on the loan to be able to keep the vehicle. So what does a debtor do when they have a secured loan? they have three options. They could surrender the collateral, which essentially decide they don't want to keep it, they want to give it up, they turn it back into the credit union, you guys sell it, and that's that. They could reaffirm the debt, or they could redeem the debt. This is typically for loans secured by motor vehicles and personal property only. That does not apply to real estate. So surrender the collateral. Once again, now we circle back to motions for relief from stay. If the stay was not terminated by law, then you typically want to file a motion for relief from stay in order to be able to recover the collateral. Most common reasons to seek relief from stay in a Chapter 7 scenario: debtor wants to surrender the collateral, debtor is delinquent on the secured loan payments, or the collateral is uninsured. I'm going to touch on the uninsured portion a little more when we talk about relief from stay in a Chapter 13 context, because I think it's a bigger issue there. I don't want to get too ahead of myself here. But ultimately, you cannot take any action to recover or sell the collateral without obtaining relief from stay and abandonment first. If you don't have relief from stay by operation of law via discharge, dismissal, or case closing, you will need to obtain relief from stay by motion. Even if you already have relief from stay, you cannot take action against the collateral unless the trustee has formally abandoned their interest. The same rule applies the other way around, where the trustee has abandoned their interest, but the automatic stay is still in place. Both can be accomplished with one pleading, but they can be filed as individual pleadings as necessary. So what is this abandonment? This is unique to the Chapter 7. As we stated earlier, when the bankruptcy is filed, the bankruptcy trustee administers the estate. He reviews the debtor's assets to see if there's anything that he can liquidate, collect funds, and distribute to unsecured creditors. So that includes motor vehicles, real estate, any kind of tangible property, investment accounts. So the trustee will not let the secured creditor repossess an asset until he's had adequate time to review it, investigate it, and make sure it doesn't have any equity. So if the trustee has not filed the paperwork with the court indicating that he's abandoning his interest in the asset, not only will you need to obtain relief from stay, but you'd have to get an abandonment order from the trustee, which we would accomplish by motion. Typically, we do it with one pleading. The Northern District of Ohio has a standard form. The motion for relief from stay does include language for abandonment, but if you do obtain relief from stay by virtue of discharge, the trustee still may be administering the estate, so he hasn't formally abandoned his interest. So you still have to wait for the abandonment. If the abandonment is not issued, then we can obtain abandonment by motion. So you have to get both in order to move forward with recovery and sale of collateral. Okay. So on to reaffirmation. If the debtor wants to keep the collateral, they typically would want to reaffirm the loan. Reaffirmation of a debt causes the debt to survive the bankruptcy discharge, and the debtor will remain personally liable for the debt post-petition bankruptcy. So what that means is, as we stated before, if the debtor gets a discharge, that eliminates their obligation to pay on that debt. By reaffirming that loan, that personal obligation survives the bankruptcy. You can ask the debtor to reaffirm any type of debt. It could be secured or unsecured. The courts have a standard form which is completed, signed by all parties, and then filed with the court. Once the reaffirmation agreement has been filed, it is effective immediately, absent an order from the court indicating otherwise. So what happens there is we prepare the reaffirmation agreement. We put in the terms of the loan. We send it to our debtor's counsel. Debtor's counsel reviews with his client. They send it back. We sign it, and we file it. As soon as that document is filed, it goes into effect immediately. There are rare circumstances where it may be set for a hearing. Usually if the debtor's budget is lopsided and reaffirming this loan would put them in the red month to month with their budget, the courts set that for a hearing. But credit unions by law are exempt from the undue hardship provision. So if there is a lopsided budget on a reaffirmation agreement, if the reaffirmation agreement is signed by a credit union, it can still be approved by the court. So absent a court order or a hearing set by the court, once the document is filed, it goes into effect immediately. The common question I get is there going to be an order approving it? Typically no. the timestamp copy of the reaffirmation agreement is essentially the order itself. Absent something revoking it, court order denying it, or the debtor has the ability to rescind the reaffirmation agreement. So they can cancel the reaffirmation agreement, but their deadline to do so is they have to do it 60 days from the date the reaffirmation agreement is filed, or when the case is discharged, whichever comes first. I'm sorry, last. I apologize. Whichever comes last. Common question that I get regarding reaffirmation agreements. What happens if a debtor does not reaffirm but wants to retain and pay? You are allowed to accept voluntary payments. It's completely at the debtor's discretion, and obviously you are at the mercy of the debtor if they opt to stop those payments. You have nothing really protecting you other than the asset itself. You don't lose your secured right, and if they fall behind on payments, you can still repossess and sell the collateral. Here's another common credit union question. This one comes up quite a bit. If they don't reaffirm, can we call them if they fall behind? Well, this is a very, very delicate situation. I would say if you're going to do that, you want to tread very carefully. I don't have an issue with you reaching out to somebody as a courtesy and saying, hey, you didn't reaffirm this debt, but you told us you wanted to keep it. You've been making payments. We didn't get a payment for a while. We're just kind of reaching out, just see what's going on. If you do decide to make that call, you want to make sure that you are very, very clear to them that you understand this debt is discharged and they're not personally obligated on it. And you want to let them know you're just calling it as a courtesy to see if they want to retain the collateral and keep making the payments. You do not want to give the impression that you're attempting to collect on the debt, because that would be a violation of the bankruptcy discharge. The third option of what the debtors can do with their secured collateral is redemption. Okay, so if we could jump to the next slide. Redemption only applies to motor vehicles and personal property. Debtor can't cram down what they pay on real estate in a Chapter 7. So redemption, debtor can choose to redeem any secured debt secured by a motor vehicle or personal property. By redeeming the debt, what the debtor does is they file a motion with the court offering to pay a lump sum payment equal to the fair market value of the collateral. In turn, the credit union would accept the payment and release their lien on the collateral. So what that means is debtor file a motion. Once again, car scenario, you have a car loan for $10,000. Blue book value shows the car's worth about $5,000. Debtor files a motion to redeem. If the motion gets granted, then the debtor has to pay you that lump sum payment of the fair market value of the car. In turn, you have to release the lien on the title. I would probably say if the debtor undervalues the collateral, it's highly recommended that you object to the motion to redeem. So that'll be a scenario, you have a $10,000 car loan, they file a motion to redeem claiming it's $5,000. You look at some NADA values or blue book values, and you make a determination that that collateral is worth $7,000 or $8,000, and they're undervaluing the value of that car. You probably want to object to that motion to redeem to try to drive that price up of what you're going to get paid. I would also recommend to object to a motion to redeem if the pleading is silent on the method and time of payment. Common problem is debtor will file a motion to redeem, value looks good, you don't oppose the value, but there's no set deadline of when they have to get you the money. Usually we want to object to kind of help guide that redemption process, to give them a firm cutoff. You don't want to be waiting for 3-4 months and no payments coming in. Typically, if we object, we want to see the payment in about 30 to 45 days, and then in turn, you typically want to release the lien on your title or send the debtor the title within that same time frame. So that's all I wanted to cover for Chapter 7s. Before I jump to Chapter 13s, I wanted to pause for a second to see if there's any kind of questions. I don't know, Scott, if there's any that came in while I was presenting, or if anybody wants to pose a question now before I jump into the Chapter 13 bankruptcies.
Okay, so there is a question regarding a debt that gets discharged on an automobile loan. There's no reaffirmation, and then later on the member falls behind in payments. Is the credit union required to send the state required right to cure letters before repossession, or is that seen as an attempt to collect a debt after discharge?
My general policy on that is you still have to comply with state law when you proceed with recovering the collateral.
That is also my understanding, and that is my advice to credit unions. You need to adhere to whatever your particular state requires in terms of noticing to a member when their vehicle is repossessed and then subsequently sold, and there's a deficiency, a right to cure, all the normal things that you would do, you still have to do with them.
The only thing I would add to that is if you do send the letters and there's concern about it being an attempt to collect the debt, I would probably include some language regarding, the bankruptcy in there, indicating that you are aware bankruptcy has been filed, that you're not trying to pursue the debt, you're just sending the letter in compliance with the law. I know that we offer services here at Weltman through our credit union group, where we, for the jurisdictions that we are licensed in, we provide the necessary letters with the proper language to protect the credit unions from those types of issues. So if you had any questions about how to draft it in a way that doesn't come back and hurt you, we can provide that service to you as well. So any other questions? Scott, I don't know if you had any other Chapter 7 related questions that came in.
So another one that was posed to us is, does an attorney have to sign the reaffirmation for the credit union to get the no undue hardship designation?
Actually, I've never had that question come up before. I would say no, because reaffirmation agreements can be signed by the creditor. I know some of you do them yourselves. That doesn't change the undue hardship, I guess, for lack of a better term, waiver that applies to credit unions.
Yep, I would agree.
Court may still set it for a hearing. I don't think they, under rare situations, they may set it just to make sure that the debtor is sure they want to do it. I don't think they have grounds to deny it. But I have had situations where debtors has reaffirmed an unsecured loan to the credit union, and the court has set it for a hearing just to give them one more chance to really think it through. But I don't think the court has the authority to deny that. So.
Thank you, Milos. And one more question that was posed is, why don't payments report when a debt has been reaffirmed? I think that someone may have been confused with something we said. It's actually the opposite. When a debtor reaffirms, a member reaffirms on a debt, you can and should continue to then report those payments to the credit bureaus. It's when they don't reaffirm and the debt's discharged that you should no longer be reporting the payments. You should simply be reporting that debt as discharged, Chapter 7.
Yeah, I'm glad somebody asked that question, because that's been a point of contention recently, and that's something that's been coming up with a lot of the credit unions. Just to reiterate what Scott said, if a debtor did reaffirm, I would report that as an active account and report it to the credit agency, same as before. What you have to understand is, when somebody reaffirms the debt, they're obligating themselves on that loan. So that loan is essentially treated as if the bankruptcy never touched it or was never filed. So all the same rules pre-bankruptcy apply to the loan if it's reaffirmed after the bankruptcy. So kind of keep that in mind. And on the same note, if a debtor's debt is discharged and they did not reaffirm, then you have to report it as discharged to the credit reporting agencies. They could call and complain and say, I wanted to keep it, I've been paying on it, but the rule's the rule. If they wanted it reported to their credit agency as an active ongoing account, they should have reaffirmed it. One more thing I want to touch on reaffirmations, and I didn't think about it earlier, is be aware that when you prepare the reaffirmation agreement and you prepare the terms, you're essentially bound by those terms. More often than not, when you prepare the reaffirmation agreement, you're going to use the terms of the original contract, where the contract left off. But if you want to entice the debtor, and this has happened before, to reaffirm, or if they've fallen behind and you still want them to reaffirm, you have the ability to modify those terms. You can reduce interest, you can take arrearages and put them at the end of the loan and extend it by the amount of the arrearage. You could do those types of things to entice somebody to reaffirm. So you're not bound by the terms of the original contract. You can modify those terms to get somebody to reaffirm or to help somebody out if they've fallen behind and still want to keep the collateral. And a lot of times I would probably say you guys would rather have the money than the collateral itself and have them finish out the loan. So that's something to kind of keep in mind. But you got to make sure that when you prepare those terms and you modify the terms, you know, that the figures add up and everything's correct. So, you know, when they make those payments, you guys get paid and everything's transparent and nothing's really missed there. So you can't leave it open-ended, I'd say, where it says, you know, we're going to worry about the arrearage when we get to the arrearage. You're going to want to make sure that that's addressed in terms of how it's going to be paid if the debtor is going to reaffirm, if you decide to do it that route. So, okay, I'm going to jump to the Chapter 13 bankruptcy. So, overview of Chapter 13. Chapter 13 bankruptcy is a reorganization of debts for individuals with a regular source of income. It involves a repayment plan to creditors for a 3 to 5 year period. The debtor retains ownership and possession of their assets, but must devote some or all of their future income to repaying creditors. The amount of money a debtor devotes to the Chapter 13 plan depends on factors such as equity and non-exempt assets and the debtor's income and expenses. A Chapter 13 debtor must file a Chapter 13 plan outlining the proposed treatment to all of their creditors. So just kind of very briefly, very generally, debtor, when they file a Chapter 13, it's the same as a Chapter 7. The only difference is between the time the bankruptcy is filed and the time the debtor gets a discharge, there's a payment plan that goes 3 to 5 years, okay? When the debtor files a Chapter 13, they have to file a plan. That plan is going to outline the treatment of your claim, okay? Unsecured claims, there's typically going to be just a general treatment for unsecured creditors. It'll offer anywhere between 0 to 100% of what you're owed. Some form plans do what's called a pot plan, where they just have generic language that says the unsecured creditors are going to share from a pot of remaining funds at the end of the plan. In those situations, you don't really know what you're going to get until the claims start coming in and the trustee kind of makes a determination on the number. But more often than not, they'll give you a figure in terms of what unsecured claims are going to be paid. Secured claims have to have specific provisions within the plan, whether you have a home loan, a car loan, or just personal property that's secured by, or a loan that's secured by personal property. That plan has to outline how those secured loans are going to be treated. If it's not provided for in the plan, you generally want to object to that plan. And we'll get to objections a little bit later. I just want to kind of give a general overview of what to expect in a Chapter 13. So, all right, first thing I'm going to touch on is proof of claims in a Chapter 13. So if we jump to the next slide. You have to file a proof of claim in a Chapter 13 in order to get paid, okay? Debtor's plan must provide for specific treatment of secured claims, such as auto loans and home mortgages. Failure to do so is grounds for an objection to the proposed plan. We already discussed that. And as stated before, unsecured claims are provided for generally. Usually a dividend of the total balance owed is what is on the plan, and it can range anywhere from 0 to 100%. So first off, proofs of claim in a Chapter 13, you always file a proof of claim in a Chapter 13 for everything. There are some exceptions, but you always want to file a proof of claim for a Chapter 13. Common mistake people have is if the plan provides for treatment of their secured claim, they don't think they need to file a proof of claim. You know, sometimes I get calls from credit union and say, you know, we didn't think we need to file a proof of claim because it says it's going to pay us. Correct, but if the payments are getting paid to you by the trustee, they're not going to know where to send the payment or how much to send you. So it's very important, particularly with secured debts, you always want to file a proof of claim. Unsecured claims too, you generally want to file a proof of claim for an unsecured debt. You won't get paid without it, and be very, very careful because the proof of claims have deadlines. Usually the deadline is 45 days from the date the case is filed. When you get that bankruptcy notice, it will have a claim deadline. If you miss that claim deadline, you will be out of luck. And in some jurisdictions, I know in the Southern District of Ohio, if you miss the claim deadline, even for a secured claim, unless there's some valid reason for missing the claim, you never got notice, they sent it to a wrong address, there has to be a really good reason for missing that claim. You're not going to be able to get a claim filed late. And very odd thing to not allow a secured claim to get filed because you're not getting paid, the debtor wants to pay you, but it turns into a big mess. So it's very, very important that you don't miss those deadlines to file a proof of claim. With regards to unsecured claims, that's going to be a business decision for you guys. Obviously, if the debtor has an overdrafted checking account with the credit union and he owes you $200 and the plan is paying 0%, you're probably not going to file a proof of claim. If it's a larger balance, you have the credit cards or unsecured loans that are, $10, $15, $20,000, even at a couple percentage points, it's probably worth it to file a proof of claim because you'll end up getting something, at least something back. Okay, mortgage proof of claims. Let's specifically talk about those. I'm gonna jump to the next slide. Debtors Chapter 13 plan must provide for specific treatment of all mortgage claims. The Chapter 13 plan will typically provide one of the following treatments. They will surrender the collateral, or they will pay the ongoing mortgage and the mortgage arrearage, if any, through the plan. Debtor can also seek to pay the mortgage off in full over the course of the plan, but this is reserved for situations where the mortgage matures during the pendency of the Chapter 13 period. So let's touch on those before I move on to a couple other things. 90% of the time, your treatment's going to be you file a claim, debtor's plan says that the mortgage is going to be paid by the debtor directly, or it's going to be paid by the trustee, one or the other. And then there's if there's a mortgage arrearage, the arrearage is typically going to be paid by the trustee. So that's going to be your standard treatment. If they pay the mortgage in full over the course of the plan, this is a unique scenario. If you have a mortgage that matures within the period of the Chapter 13, so let's say the Chapter 13 goes for 5 years, and you have a mortgage that matures 2 years in, they can actually re-amortize that mortgage and have it paid in full and over the course of the plan. So they don't necessarily have to pay it in year 2. They can take the total payoff and spread it out over the course of the plan. But that's only in scenarios where the maturity date falls within the plan period. A debtor cannot cram down a mortgage on their primary residence, but they can strip a wholly unsecured mortgage off their primary residence. So what does that mean? You have a mortgage, $150,000. House appraises at $100,000. They cannot cram you down. They have to pay the $150,000. But let's say you have a second mortgage and you're sitting behind that $150,000 mortgage. They can completely strip a wholly unsecured mortgage. So if the house is worth 100, there's a first mortgage holder ahead of you that's owed 150, and then you have a home equity line that's owed 50. If they can prove the value of that house is 100,000, they can strip that second mortgage as wholly unsecured. So what happens is that second mortgage that's unsecured will be treated as a general unsecured creditor for the duration of the plan. So what you have to remember is it's also contingent upon discharge. If the debtor strips that mortgage and they go 3 years into a 5-year plan and they don't make it all the way, that mortgage is not stripped. And if that case gets dismissed, you're entitled to pursue that mortgage and go back and pursue that all those months where the debtor was not paying you because they were assuming it was going to get stripped in that Chapter 13. Debtor can cram down mortgage on a non-residential property. Usually you see that with rental property or second homes. I have not seen that happen for a very, very long time. Usually if people are filing for bankruptcy and they have a bunch of rental properties, that's typically the cause for their bankruptcy. I have not seen somebody attempt to do that in years. It's probably maybe not to their financial benefit, or it hasn't been in a very long time. As stated before, the mortgage payments directly to the credit union will be either what's called a conduit, which is by the trustee through the plan, or it would be paid directly by the debtor. The mortgage arrearage will always be paid by the trustee. It will never be paid by the debtor. Scott, did you have a question come up?
I have had some questions come up.
Okay.
Yes, I have.
I'm going to take a break so we could answer those questions.
Yeah, let's have a couple of them right now.
Okay.
So one of them you just kind of touched on was how is it handled with accounts to be paid outside the plan? Is this similar to a reaffirmation?
I would say yes. One thing to keep in mind is mortgage loans in a Chapter 13, if the mortgage payment extends beyond the duration of plan, which most of them do, they are not discharged. And I don't know, I'm trying to see if I can word it in a way to make sense. So if the debtor has a 30-year mortgage and they plan on paying the mortgage directly to the credit union, and they're not altering the terms, they're just paying the mortgage every month, the case discharges and there's still another 25 years left on that mortgage, that mortgage is not discharged. But that applies also whether they pay directly or whether the trustee pays. So long as the last payment on that secured long-term debt is due after the bankruptcy is completed, it's not subject to that Chapter 13 discharge.
Yep.
Scott.
And I would also add, you'll get a rare occasion where number one, a debtor will want to pay a car directly, and number two, that car loan could be one of those 84-month loans that the last payment is going to extend beyond the end of the Chapter 13 plan. Same thing applies. They can pay you direct, and then essentially the debt survives, all the loan terms survive, and they just have to keep paying you beyond the plan once the Chapter 13 is over.
Okay. All right, I'm going to jump back into this. We got about 15 minutes. There's quite a few things I want to, so I'm going to try to get through as quickly as I can. Motor vehicle claims. Debtors Chapter 13 plan must provide for specific treatment of all vehicle loan claims, same as the mortgage. Chapter 13 plan will typically provide one of the following treatments: surrender the collateral, pay the loan in full over the course of the plan, which is the most common, continue to pay the loan directly to the creditor outside of the plan, which is uncommon. The debtor can cram down the secured amount paid on the vehicle, but only if it meets two conditions. Otherwise, the loan must be paid in full. If the loan was taken out within 910 days of the bankruptcy or less, they cannot cram down the loan. So if the loan is older than 910 days at the time the bankruptcy was filed, they're allowed to cram it down. But the second condition is, if they're going to cram it down, the fair market value of the collateral has to be less than the balance of the loan. So if the loan is eligible for a cram down, they still have to get over the hurdle of the value. So if you're owed 10,000 and the NADA is showing 15, even if the loan is no more than 9 or 10 days old, there's enough equity there that they cannot cram it down. If you ever see the debtor attempt to cram down a loan for a loan that's less than 9 or 10 days old, or you're showing a value more than what you're owed, you typically want to object. One thing to keep in mind is that 910-day, and the value cram down only apply to loans that are purchase money security interests. If the debtor used the credit union to refinance the loan, or they put up a paid off car as collateral to obtain a secured loan, they can still cram that down. So keep that in mind. The other thing, the common question I get is, they're paying the car in full, but they're cramming down the interest rate. They're allowed to cram down the interest rate. The interest rate can always be modified in accordance with the case of what's called in re till. It was a bankruptcy case that was decided a long time ago that determined what the appropriate cram down rate is. The cram down interest rate is typically calculated using the prime interest rate, the current prime interest rate, plus an additional 1 to 3% percentage points. I think right now prime is 2 something, maybe 3. So you're seeing what's that?
I think it's 3 1/4, I believe.
So you're typically going to see a cram down interest rate about between 5 1/4 and 6 is what the norm is. And every district's different. Northern District of Ohio literally sets it at prime plus 2. And then the trustee automatically pays it unless indicated otherwise. But that's usually what you're going to be looking for. Okay, objections to the plan. Debtors filed the bankruptcy. You filed your claim. You reviewed the plan. Should you object? If the debtor's plan fails to provide for satisfactory treatment of your claim, you may want to object to the plan. Carefully review your claim's treatment in the plan. Typical grounds for objection would be failure to provide for treatment of a secured claim. Yeah, like I said, if you have a secured claim, they have to tell you what they're doing with it. If they don't, you want to object. Incorrect arrearage amount. They're delinquent on the mortgage and they claim that they only owe you 10,000, but you're showing 20. There may be some feasibility issues or other issues. You probably want to object if the difference is pretty lopsided. Attempting to cram down a home mortgage or an auto loan when it's impermissible to do so. So like we stated before, there's certain scenarios where they can strip a mortgage, cram down a mortgage, or cram down an auto loan. If they're trying to do that in the bankruptcy and they're not allowed to, you definitely want to object to that. If you see surrender and full satisfaction language, what does that mean? A lot of times debtor may want to surrender collateral in Chapter 13. What they'll do is they'll put in some special provisions stating that they're surrendering the collateral in full satisfaction. What that means is if that plan gets confirmed with that language, they're anticipating when you repossess and sell that collateral, that's going to satisfy the loan in full, whether there's a deficiency or not. You usually want to object to that because if you have a deficiency or anticipate a fairly large deficiency, you want to retain your right to be able to file an unsecured claim through the plan, particularly if the plan is paying a pretty sizable dividend to unsecured creditors. And lastly, attempt to reduce interest rate. You want to object to the plan. Now, I know we said before, well, I thought you said they can reduce interest. I said, yes, they can, but they can't reduce it to 0% or below TIL. If the interest rate, if they're trying to cram down your interest to 0% or a really low number, then you probably want to object because you're potentially leaving money on the table, depending on what the balance of your loan is. Okay, last item I want to touch on is the motions for relief from stay in the Chapter 13. There's one specific issue that's come up quite a bit, and I want to leave enough time to touch on that. If the debtor's Chapter 13 plan indicates the intent to surrender the collateral, you will still need to seek relief from stay in order to recover and sell the collateral. Otherwise, you'll have to wait until the debtor's plan has been confirmed by court order. So if the plan indicates it's going to surrender the collateral, that plan does not take effect until it's confirmed. And that could be, months, even years down the road. So you have to wait for a confirmation order if you don't seek relief from stay. Other grounds for motions for relief: if the debtor fails to comply with the terms of the plan, that can also serve as grounds for seeking relief from stay. This would typically be situations where the debtor is not paying the claim directly as agreed or is not funding the Chapter 13 plan, which results in the trustee's failure to pay the claim. So if it's a direct pay and you're not getting payments, or if it's a pay to the trustee and the trustee hasn't sent a few payments for a few months, and then we look at the plan and see he's delinquent on funding, you want to file a motion for relief from stay. All right, last one, and the one that's most important, and I want to touch on because it's come up quite a bit, is it's also highly recommended you seek relief from stay if the collateral is uninsured or if you are unable to confirm it is insured. All right, so this has been a big issue lately with the credit unions, the forced placed insurance. So typical scenario, debtor has a car loan, they don't insure the car, you guys are paying for the forced placed insurance. I get a call and say, debtor's paying the car loan through the plan, but they're not insured. Now we paid $2,000 to get this insured for the full year. What do we do? Well, you have two options. You can file a notice of post-petition fees to file a supplemental claim to recoup that money, or you can file a motion for relief. I would probably say almost every time you want to file a motion for relief, because the problem is when you file a notice of post-petition fees, they have an ability to object to that. The second thing is that doesn't get your car insured. If they continue not paying, you're going to have to do that every year for the duration of the plan. And what's going to happen is at some point in time, the debtor is going to build up so much negative equity because you keep paying for that forced place insurance. They're probably going to say, this car is not worth, the money that I owe plus the forced place insurance that was put on the loan. I just want to surrender the collateral. You're never going to recoup that money. I think the best approach is to be aggressive. You file the motion for relief from stay. Uninsured collateral is grounds for relief, and then you bring the debtor to the table and you force their hand. There's a couple benefits there. One is you're not continuously paying that forced place insurance premium and ballooning the delinquency on that loan. Second of all, when we file the motion for relief from stay, you're bringing the debtor to the table and you're forcing them to take action to address the issue. And third off is we typically, whenever we file a motion for relief from stay for these scenarios, we typically refuse to resolve this, even if they provide proof of insurance, unless they're willing to reimburse the credit union through a supplemental claim. So then we're guaranteeing that this car or this collateral is going to get insured, and we're also guaranteeing that you're going to get paid over the course of the plan for what you spent out of pocket to make sure that this collateral was insured. So I kind of breezed through that pretty quickly. I wanted to leave a few minutes for some questions on this last part, or some general questions. And then obviously, if anybody has any follow-up questions, my contact information, if you don't already have it, will be available at the end of the webinar, and you guys can reach out to me directly. But Scott, did you have any questions that have come up, or ones that we haven't addressed yet?
Yeah, I do have a couple. So one question was essentially, does a debtor have to include all of their debts in a Chapter 13 plan, or can they exclude some?
Yes, they cannot pick and choose. I know they come up and say, credit unions get calls and say, well, the debtor told me they weren't going to include us. It doesn't exactly work that way. They have to list all their creditors. If they want to maintain their membership or good standing with the credit union, there's other ways to do that. Pay it through the 13, reaffirm the loan. They can't just omit the debt from the bankruptcy. It has to be included, and then we deal with it after the bankruptcy's been filed.
And an important thing to note is, in a Chapter, which this leads to a second question, is what is discharged in a Chapter 13? What's covered by a Chapter 13 discharge?
Everything that would be in a Chapter 7, with the exception of long-term debt. So, medical bills, unsecured loans, all that stuff. Cram down car loans, everything. But if like we said, long-term debt, where the debtor is paying direct or paid through the trustee pursuant to the contract, and that final payment is due after the bankruptcy is completed, that loan is not subject to the discharge. So that would almost always only be mortgages, and under rare circumstances, cars, if they're paying direct and the loan is now they're given, like Scott said, 72 or 84-month car loans. Before it was 60 months was the ceiling, and these plans go 5 years. So you very rarely see a car loan extend beyond that final date, but it's becoming more and more common. So I hope that answered the question. If not, my connection got lost. Look, Scott's connection got lost, so he actually just walked into my office. Yep. So, all right. Any more questions?
No, I think that pretty much covers it.
Okay. We've completed here with a couple minutes to spare. Like I said, if anybody has any more questions or concerns, you guys can reach out to me, Scott, or any attorneys you feel comfortable with here directly, and we can answer any questions you may have. Also, please make sure to give us any feedback, particularly if there's any specific topics that you want us to touch on in more detail. I know we're trying to give a general overview of bankruptcy here to help you guys troubleshoot through some scenarios. But if there's any specific topic that you think we should go into more detail on, maybe we could think about setting up a specific webinar for that.
So I'm going to just conclude by thanking everybody for attending today. We do hope you found the presentation informative. As a reminder, there's going to be a short survey which is going to pop up on your screen when the webinar ends. So please share your feedback. Let us know what future webinar topics you'd like to see. I'd also like to share that we do have a complimentary library of over 20 webinars that you and your team can view on demand. Our collection offers information on a variety of topics, including bankruptcy, real estate, the Bank Secrecy Act, to name a few. So we'll send you a link to the library in our follow-up email. And thank you again for attending, and have a great rest of the day.
All right. Thank you guys very much.